There we go. Okay, I'll call to order this hearing of August 14th, 2025 in the matter of a remand of Z0123-23. My name is Joe Turner. I'm the county's hearings officer. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I'm not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Planning Commission and Board of Commissioners to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearing, I am not a county employee. I am licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. And as a hearings officer, I'm to provide an unbiased decision maker. And I believe I am unbiased with regard to this remanded application. I have not had any pre-hearing contact with the parties regarding the substance of the application other than the testimony and evidence in the record from the prior hearings. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Um, Procedure will follow. I'll start by asking staff to summarize their response to the remand order. Then the applicant will have the opportunity to present their response to the remand order. If anybody else wants to say anything in support of the application, they may do so. And anybody else who wants to testify in opposition or with questions or concerns about the application may do so. Once everyone's had an initial opportunity to testify, I will give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing without taking any additional public testimony. As noted in my remand order, I will hold the record open after this hearing for, I believe it was a total of 3 weeks. I'll check my order at the end of the hearing and confirm specific dates. But I will hold the record open. If anybody wants me to hold the record open for a longer period or continue the hearing, you can make that request during your testimony. Sorry, I had a thought there and it's gone, but threw me off my usual spiel. Anyone with an interest in this remanded application may offer relevant oral or written testimony, but testimony must be relevant to the issues on remand. Also, please don't repeat testimony offered by yourself or earlier witnesses. It's not a popularity contest. Whether everybody loves it or everybody hates it is not an issue I get to consider. The only issue before me is whether the application does or does not comply with the applicable approval criteria that were related to the remanded issues. It is important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, as everyone I'm sure is well aware with the prior history of this one. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that people can understand what the issue is. Also, my decision must comply with state law that requires that I issue a final written decision within a certain amount of time. And I've got a specific by November 14th, 2025 on this remanded process. So there's some limit to how long I could continue or hold the record open beyond what I've already set out in my order. When you testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right. And if you represent someone else, please say so. Ms. Lord will give us an outline of the online procedures, how you can indicate that you'd like to testify, etc. Ms. Lord?
Thank you. I'll go ahead and share my screen here. Make sure we've got the right one. All right. Let me just see. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county's website later today. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members' cameras will not be turned on at any time. The audience members' microphones will be muted unless they wish to testify, in which case they'll be called upon to do so by the county staff moderator. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you'll have to use the raise hand button on your computer, or for people joining by phone, you can press *9 to raise your hand. Staff will call upon you when it's time for you to provide your testimony. You will unmute your microphone and provide your name and mailing address when you begin. Once you've provided your testimony, you can lower your hand and your microphone will be muted again. If the record is left open at the end of the hearing and you wish to submit additional written testimony, you can email that written testimony to myself at mlord@clackamas.us, or you can mail it to the Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City 97045. My email address is also available on the webpage where you found the link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. For people who testify and provide their mailing address, you will receive a copy of the hearings officer's final decision. If you do not wish to testify but would like to receive a copy of the decision, you must provide your email or standard mailing address by emailing me at mlord@clackamas.us or by entering it into the Zoom chat function during today's hearing. And with that, I did prepare a small presentation just summarizing where we're at and a quick discussion on staff's perspective of the remand issues. So,
Okay, Ms. Lord, before we proceed with that, I see we have a raised hand. Mr. Capillas, do you have a procedural question or do you just wish to testify? If you want to testify, please click on the raise your hand button. Well, you can click on that again when you when we call for testimony from the public, but his hand's still up, so I'm assuming he has a procedural question. Can we unmute Mr. Capillas or promote him? There we go. Mr. Capillas, you had a question? And am I pronouncing your last name right? You'll need to unmute yourself. We're not hearing you yet. Mr. Capillas, we are not hearing you. He is unmuted on our end. Mr. Capillas, I'd ask that you try logging out and logging back in and see if that allows you to, if that fixes the muted issue. So if you log out and log back in, raise your hand again, we'll come back to you. Well, I don't want to proceed until he's back so he can hear your summary. So
not a problem.
Mr. Capillas, we're still not hearing you, and you still have your hand raised. Mr. Capillas, we're not hearing you. Mr. Capillas, I'm assuming you're hearing us. Can you log out and log back in? There we go. He logged out. We'll wait till he returns. Okay, he's back. Can we unmute him? His hand's not raised though. Let's go ahead and unmute him anyway, just in case. Yep, there is hands raised. Mr. Capillas, there we go. Now we hear you. Mr. Capillas?
Okay, great. Thank you. No, I was just having a lot of technical difficulties here. I had joined the meeting earlier, but I didn't even see anything on my screen that would allow me to mute or unmute or set any of my settings.
Yeah.
So anyway, I'm glad to know that you can hear me now. Thank you.
Did you have a question?
No, I don't have a question at this point. I would like to testify though at some point when we're ready to do that.
Okay. Okay. Thank you. Appreciate it. Go ahead, Ms. Lord. We're not hearing you.
I'll
There we
share
go.
my screen again. There. So like I said, just a quick summary. You're seeing my PowerPoint, yes?
Yes.
Great. Quick summary of the project itself. So the properties on Beaver Creek Road, slightly less than 20 acres in size, and zoned ag forest. The initial approval for the conditional approval for the project was to host up to 52 events per year, no more than 5 events per week, and that would host up to 100 guests per event. The events were to take place substantially in an existing barn. It's about 3,000 square feet in size. And the initial request and approval was to authorize a 1,400 square foot dressing building is what it was called. And the dressing building had a kitchen, 4 restrooms, and changing rooms. So that was the initial approval. This project, as I think we all know, has bounced around quite a bit. So the initial hearings officer decision was issued back in March of last year, 2024. That decision was appealed to the Oregon Land Use Board of Appeals, which remanded this decision based on a couple issues back to the county. That LUBA decision or Land Use Board of Appeals decision was appealed to the Oregon Court of Appeals, which reversed some of the remand issues and remanded back to LUBA. Then there was a petition filed to have that reviewed by the Supreme Court, which was denied back in April of this year. The LUBA then remanded the decision back to the county solely to address one singular issue, which was whether the dressing building was appropriate or was a building similar to that you would see that's allowed in the ag forest zone. The applicants did request the county to proceed with the remand of this project based on that one singular issue. And so the question today really is, well, the applicants then proposed to withdraw the dressing building. So the question today really is the withdrawal of the dressing building going to impact any of the review criteria, the applicable review criteria that have already been found to have been met? So again, the updated proposal effectively is to host the 52 events per year, 5 events per week, for no more than 100 guests per event within that existing barn, and then the applicants have withdrawn that request to construct a dressing building.
Okay, thank you, Ms. Lord.
Yeah, and so just real quick, our review of the zoning and development ordinance, we find that removing the dressing building is not going to affect any compliance with the approval criteria in the ZDO. Permanent restrooms were proposed in the dressing building, but not the barn. Portable restrooms are allowed in the ZDO, and they were included as part of the original conditional approval. There are some regulations around how far the restrooms can be from property lines, things like that. And so we do already have conditions of approval built into that initial decision. I will note, though, that while it's not a requirement of the ZDO, and so this truly is just an advisory note, I am aware that both the building department and the septic department, which have regulations outside of the ZDO, are going to require permanent restrooms on site for this event center. That's something that we would typically advise during the review, but with the removal of that dressing building, I don't believe that there are any permanent restrooms proposed in the barn. So I would make a recommendation to the applicant that they might want to update the floor plan during this open record period to include a permanent restroom and make sure that it does still meet the applicable zoning criteria that are in consideration or in question today. But again, the requirement for permanent restrooms is not a zoning and development ordinance requirement. So my statement that removing the dressing building won't affect the compliance with the approval criteria is still valid. So that is the extent of the presentation I have prepared.
I guess the issue then is whether permanent restrooms are permitted in the as a use in the normally accepted use in the ag forest zones.
And we do through and through, every day, I would say, maybe that's an exaggeration, but we do approve permanent restrooms in ag buildings, barns, buildings that are on exclusive farm use zoned properties, ag forest zone use properties, and timber zone properties, all the time in Clackamas County. It's a very common use and a very common thing that we see in these barns. So I do feel confident in saying that is something that we authorize often.
That was my
in
understanding
Clackamas
from
County.
prior hearings, but I just wanted it on the record here.
Yeah.
Thank you, Ms. Lord.
Mhm.
Mr. Hall, it's your opportunity for the applicant.
All right, thank you, Hearings Officer Turner. For the record, my name is Damian Hall, here on behalf of applicant Sage and Social LLC. Appreciate the opportunity to speak with everyone this morning. Would like to thank the hearings officer as well as Ms. Lord for your orders setting the scope of this remand hearing, as well as all your hard work on this over what's become a long time. I think in the remand procedure order, it said that last March was when this was initially approved by the county. And so the appeals process is now going into a year and a half. But Ms. Lord has been along for the ride even longer than that. I think we were somewhere around the 365-day mark on the clock, 100 from the original application. So this thing's been pending since early 2023, which we have a wonderful land use system in Oregon that allows these things to be determined with lots of specificity on a whole lot of levels. However, through that process, I think we've winnowed it down to one issue, and I'm here to tell you that there aren't actually any standards associated with that issue that need to be satisfied here today. I agree completely with Ms. Lord's summary of kind of how we got here and what's at issue today, and it's really just the accessory building or the dressing building. The applicant is standing by and would reaffirm its proposal to remove the dressing building. And I've taken a look at the original approval from the hearings officer, and none of the findings, other than to the accessory building standards, are dependent on or involve the existence of the dressing building. So that includes the impact standards at ORS 215-296-1 and ZDO 401.05A1 about not forcing significant change in farmer forest practices in surrounding areas or increasing the cost of such practices. The applicant's position is that the dressing room does not impact those practices one way or the other. So the adjacent parcels will still be able to do exactly what it is that they choose to do as far as farm and ag practices, and the cost will not be increased, nor will those practices be made more difficult. We put that in slightly longer form in a memorandum that we submitted on the 7th, so last week, and don't really have more evidence to provide. We'd just like to say that the prior decision got it right on the home occupation and the ability to use the barn for events. We defended that decision for a good bit, up a couple levels, got the highest court in the land to agree, or the highest court in the land that wanted to hear about it to agree. And, we think that it would be a very high bar to show that not building a building is going to impact surrounding agricultural areas. On the issue that Ms. Lord brought up about permanent restrooms, I think that the existing conditions solve for that, because we are conditioned to get a septic permit as well as a building permit. And that's where any permanent restroom requirements would be applied. However, to the extent that the hearings officer thinks that additional flexibility would be needed if such a restroom were to be included in the barn, we'd be okay with having the ability to do that. So I'm not sure that it's necessarily proposing a whole new layout and redesign of the interior of the barn, but simply a condition of approval that says, to the extent it's required, you know, nothing in this order precludes utilizing the barn for a permanent restroom. But I think that we are able to likely handle that with the building and septic folks, as opposed to in necessarily being part of the conditional use and reopening that scope. And as I read it, the existing approval of the home occupation would not preclude, you know, any kind of like specifics of what the design of the interior of the barn looks like, including a restroom. So I think we can get there without reopening any of those issues. So that I believe is the totality of what I have to talk about in this process. Still reserve the right for rebuttal, but would open it up to any questions from the hearings officer, but want to keep it fairly short and sweet.
Okay. The only question I had is in your memo, you also request the use of temporary tents until the building permits are required for the approved barn. I thought you were going to use the existing barn. So was that just an accidental carryover?
No, I think, I believe this may be allowed, right? So last time we were here, we're in kind of a different posture. We're asking for alternative A or alternative B kind of thing. Alternative A turned into a lot, was to use the barn as conditioned. Yeah, as conditioned, it says, get your building permits within 6 months and then use the barn. I believe the subtle difference in the ask really is, in those 6 months before the barn, prior to getting the building permits, can we use
you need to get right. You need to get building permits for the existing barn because it was an ag exempt building.
Yep.
Okay.
And
that answers that question.
Yeah, by way of context, a lot of that has gone forward during the appeal process. We're very confident we can get the building permits within 6 months.
Okay. But that was my next question is there is a condition in my prior order that requires you get the building permits within 6 months and start using the barn with it. Does it allow temporary tents for 6 months?
Yeah, so I think we would just request, and I can provide a proposed condition, but I think the request is really along the lines of just clarifying that the temporary tent can be used in that pre-building permit timeline.
As long as there is some deadline that the tents no longer be used because it's required to be primarily in the barn, basically. I don't remember. Okay.
Yeah, and there is substantial evidence in the existing record. If you recall, we've done all of the analysis based on there being part of the events happening outdoors, well, the sound attenuation and lights and different things, are based on the sort of like the least impacted scenario, which is why we have a finding that temporary tents would be allowed, but we do have a condition that says primarily those should be used. Temporary tents should be the secondary area in the events. So just for that limited window, pre-building permit, we would ask for a condition allowing the use of temporary tents as the primary area.
Okay. Thank you, Mr. Hall. That answered my question. Does anybody else want to say something in support of this application? Not seeing anybody. Mr. Capillas or anybody else like to testify in opposition or with questions? And Mr. Capillas, you said you wanted to testify, so we'll go ahead and unmute you first. Okay, Mr. Capillas, you're unmuted on our end. Looks like you need to unmute yourself. There we go. Oh, maybe things keep, there we go.
Okay, great, very good. So my name is Greg Capillas, for the record. I live at 18487 South Valley Vista Road, Lino. Um, I'll try to keep this as brief as possible. So the proposed addressing building would have included, among other things, 2 bathrooms and a kitchen designed to serve up to 100 people. I understand that when the applicant has been holding events, it's not unusual for them to have 2 or more food trucks and a beverage truck, adult beverages, alcohol. I want to talk about ZDO 80602B, which limits the number of employees. But first, I guess I just want to throw out a sort of a fundamental question for what it's worth. I think the county needs to consider are having 3 or more food and beverage carts and a whole row of portable toilets lined up, considered uses that are normally associated with the zoned activities. Going on to the number of employees, according to ZDO 80602B, the home occupation shall have no more than 5 employees. ZDO 80601A defines employee as pretty much anyone who's working on the home occupation, full-time or part-time, including the operator, partners, assistants, and in ag forest districts, anyone employed by contract to provide services for a single event, such as caterers, photographers, and florists. So let's consider what I think is a kind of a plausible scenario for a wedding party of 100 people. You've got to have somebody there, event support, maybe including the operator and 1 assistant. That's 2 people to help with organization, setup, decorations, etc. I understand, again, often there's 2 food trucks. I don't know how many people staff those trucks, but I think typically they've got 2 people in each truck. That's 4 people just for the food trucks. Now you've got a beverage truck. You're serving 100 people, might have 2 bartenders. That's another 2 people. Then you got a DJ, you got a photographer. So that adds up to 10 employees as defined under ZDO 80601, which is double 80601A, excuse me, which is double the number allowed under ZDO 80602B. I mean, using even what I think are unrealistically conservative estimates, let's say you've got 1 person providing event support, which is hard to imagine. 1 person could do all that. 1 person per food truck. You could still need 2 food trucks. So that's 2 people. You got a bartender, maybe 1 bartender in a beverage truck, a DJ, a photographer. You're still up to 6 employees, which exceeds the limit. So I guess when I look at that, I can't help but wonder how they can realistically operate, using the food trucks and a beverage truck and keep the number of employees at 5 or less for a sizable event.
Okay.
I also want to talk about the appearance ordinance, ZDO 806-020, or O, which says that on non-event days, the use shall not take on outward appearance or manifest any characteristics of a business or operation or service commercial nature, except for those characteristics normally associated with or allowed for a primary use in a subject zoning district or in the ag forest district for a use identified as allowed by table 407-1.
Mm-hmm.
So we understand that the portable toilets that are currently being used are often left in place on days between events. A whole row of portable toilets would pretty clearly, I think, take on an outward appearance or manifest characteristics of business or operation of service commercial nature. Further, it would be a stretch to claim that the use of portable toilets to serve up to 100 people would be normally associated with a primary use in an ag forest district or would fit any of the allowed uses listed in table 40701. So I guess what I'm trying to get to here is that I think that when they're using the portable toilets, they're going to have to be removed from the property on non-event days. I didn't really have anything
That
else.
first issue, Mr. Capellas, that first issue may go beyond the scope of the remand. I've accepted your testimony and I will consider it, but I just want to let you know that
I believe it does fit the scope because I'm
Okay.
addressing an issue that basically because they can't use the
Okay,
they will
good
not be
point.
using the dressing room, right? That forces
Yeah.
them now to use beverage carts. And I think that may very well increase the number of employees that they're going to have on site. That's the point I'm trying to
Okay.
make.
Thank you. I appreciate the clarification, and that makes
You're
sense.
welcome.
Yeah, let me finish my note, and then I'll, if you want to proceed in just a second here. Okay, go ahead, Mr. Capellas.
That's all I had. Thank
Okay.
you very much.
Thank you, sir. If you'll go ahead and mute yourself again, Laura Van Tyne.
Thank you. My name is Laura Van Tyne. My mailing address is P.O. Box 677, Oregon City, 97045. Sage and Social's desire to withdraw the construction of the dressing room home from the property raises more questions as to how that enhances the conditional use permits. In reference to ZDO 806.020, Sage and Social are violating appearance standards by not removing the portable restrooms between events. The portable restrooms are permanent and they are not taken down after each event. Without proper sanitary systems such as running water and toilets, there will be an increased dependency upon portable toilets. Managing these portable toilets permanently is not an authorized use. In reference to ZDO 806.02b, Sage and Social relies on food trucks and vendors to feed their guests.
Okay,
This,
Ms. Van Tyne, Mr. Capellas has already raised these issues, so there's no reason to no need to repeat it.
okay, we did not have a chance to talk
Yeah,
because
that's okay. But I understand you're agreeing with his regarding the food truck.
yeah, and in addition to the food trucks, there's DJ crews, officiants, florists, videographers, wedding coordinators, other staff that is needed to manage these.
I
And
understand.
also, there is a huge hypocrisy here. Farmers are not permitted to establish processing facilities or any other types of businesses on their land. However, Sage and Social have hosted and continue to host large-scale commercial events with over 150 people, which is illegal. This is a farm forest ag zone property. And in conclusion, removing the dressing room home does little to improve existing farm, forest, or agricultural practices that are already in place, as their activities conflict with such uses. The applicants are trying to slap lipstick on this pig by removing their dressing room home. The law is the law, and Sage and Social are in violation of many land use and building code laws, as they have never received inspections or building permits. And lastly,
Okay.
they intentionally break the laws, and what's stopping them from erecting a few tents and sending their guests straight into the barn?
That is an enforcement issue. I can't deny this based on assumptions that they may violate the law. The existing operations without approvals is also an enforcement issue. That the only issue before me is what happens from here on if I approve this application. And I have to impose conditions of approval, and I have to assume that they will comply with them. And if they don't comply with them, the county will bring enforcement action, which can include revocation of the conditional use permit. So the applicant has a strong incentive to comply with those conditions. As
Thank
far as whether this use should be allowed in the ag forest district, it is. That's a policy choice by the state and the Board of Commissioners, whether that it is allowed. Because it's allowed, if it meets the criteria, I would have to approve it. So that's the issue before me, is whether it complies with the
I
criteria.
appreciate your time. I just got this late last night, so this was a quick preparation, but I
No
appreciate
problem. I just want to let you know how I'm reviewing this. So I appreciate your testimony. Did you have anything else you wanted to add, ma'am?
that's all. Thank you.
Okay, thank you. Is there anybody, Ms. Van Tyne, can you mute yourself again? Is there anybody else who'd like to say anything about this application in support, opposition, or with questions? If so, please raise your hand now. And I'm pausing just in case somebody's looking for the raise your hand button, but not seeing anybody. Anything further from staff, Ms. Lord? Okay.
Nothing, thanks.
Mr. Hall?
All right, thank you. One moment here. So, quick rebuttal. Um, Essentially, two issues were raised: one about employees, one about whether temporary restrooms, should be moved or not. I think that both of these issues are solved in law in the rule of the case. They're addressed directly by the existing approval conditions from the prior decision. Could have been challenged had folks wanted to last March. We are now a year and a half later. It's outside the scope and should not be addressed. All that being said, it's worth noting sort of how these things are addressed and what the code does say, because the code is pretty clear on what is and what is not an employee, and it's not everybody. And it's not all the caterers, it's not all the folks that work uh, and have anything to do with an event. Taking a look at 806 01A, definition of employee: persons employed by contract to provide services for a single event, such as caterers, photographers, and florists, are not considered employees. That's what the code says. So,
I thought, but I didn't have it in
yeah,
front of me.
well, while it's outside of the scope, it's also pretty clear. And then, as far as the restrooms, you know, I believe that, we have kind of that open-end issue that needs to be addressed through building permits and septic permits about how the restrooms are addressed. I believe that the condition, as mentioned earlier, the condition of approval address that. We do appreciate the flexibility to the extent that the applicants want to or need to propose a permanent restroom within the barn building uh, to go ahead and to be able to do that. But basically, we feel that that's a building permit issue. We'll obtain the building permits before occupancy and comply with the conditions of approval regarding the home occupation, including all of the different ways in which a home occupation should not look like an event on days where there is no event.
Thank you, Mr. Hall. One comment, I guess I would say. The
Yeah.
original approved with the proposal with the dressing building, that included 4 restrooms. So by removing that, you're removing 4 permanent restrooms, increasing the number of portable restrooms you'll need, at least unless and until you provide permanent restrooms inside the barn. So that's something I would, if you can respond to that concern or that issue during the open record.
Absolutely.
Thank you, Mr. Hall.
And
Anything else? Go ahead, Ms. Lord.
oh, I was going to ask, if you do approve the application subject to conditions, in this line of thinking, then I would just request, on behalf of the county, that we have some clear direction as to how, maybe how many restrooms are being authorized in the building, or, are the doors accessed from inside the barn or outside the barn, just, more guidelines that if and when I do see the building permit for this, that I can see a floor plan that differs from the one that we've seen in the record so far, and just know that that is an allowed modification. Thanks.
Yeah, I appreciate that concern. In considering how to draft such a condition, I have no idea how many restrooms would be needed. So that's something, if the applicant wants to submit new evidence about that issue, everybody can respond to that new evidence during the second week of the open record period. Or the applicant wants to provide some argument.
Might I ask a follow-up on that?
Absolutely.
Yeah. So the issue of flexibility to add a permanent restroom to the barn, first came up in Ms. Lord's initial presentation today. I'm not familiar with a standard that's applicable on remand that would require us the applicant to have permanent restrooms. There was a reference to ADA standards, and we will find compliance with ADA standards, whether those are in permanent or temporary facilities. But you know, what I think the baseline is Ms. Lord has a good idea. We would like the flexibility to do it, but we'd have to like run down the logistics of what it looks like. However, I don't believe that the ZDO requires
I think you're right, and she said
specificity
that
about,
expressly.
you know, the access to the restrooms and the specific amount of permanent restrooms. What our request simply will be, and I'll put this in writing, is flexibility to that, to if it is the right way to go and are pushed that way by the building department, to include a permanent restroom that meets the applicable standards in the barn. Not to codify what standards are applicable at the building permit process within the conditional use.
My only concern is if I approve this subject, if there's no specificity about what kind, how many restrooms and how they'd be accessed, that I don't want this to have to come back if the building or septic department requires indoor restrooms. Indoor restrooms might arguably change the scope of the building, the design of the building. If there were a number of restrooms in the building, is that building still an ag, normally associated with uses allowed in the ag forest zone? And where those the restrooms are accessed exclusively within the building, then I don't think that is an issue. But if there's outdoor access, then people are coming in and out from outside, potentially, arguably increasing the impacts. So those are the first thoughts that come to mind, I guess let's say.
Yeah, agreed. So
Okay.
yeah, just
if you can address that during the open record, and I'll take it
we
from
will
there.
absolutely. And I think where we are is, the original proposal for permanent restrooms within the dressing building. In addition, allowed specifically by condition and specific findings of compliance with the proposal to have outdoor temporary restrooms as well. And so I think we have the record that demonstrates that we comply with the allowance of outdoor restrooms. I've, looked through and kind of gone through the decision and don't believe that there is any standard that requires the 4 permanent restrooms. Although they were a good idea. So then being proposed, and I'm not here to say they're a bad idea, but we're removing that from the current proposal.
I understand.
To try and resolve the outstanding land use issues that our good friends and neighbors around the area continue to raise. So I'll absolutely write that out, but just want to provide current thinking as far as that's likely to look like a set of written arguments as opposed to new evidence and a redesign of the barn in short order or anything like that.
Okay. If you want to propose condition language that would address those concerns, I'd appreciate it, but you should submit that during the first open records. Everybody has a chance to respond to it during the second, including the county.
Acknowledged.
As I noted at the intro, there is no opportunity for further public testimony. So I see Ms. Van Tyne's raised hand. Unless Ms. Van Tyne, if you have a procedural question, go ahead and we'll unmute you. But if you just want to offer further testimony, I'm not going to allow that. So if you have a procedural question, keep your hand up. Otherwise, please lower your hand and we'll. So can we unmute Ms. Tyne, see if she has a procedural question? Van Tyne, sorry. There we go.
Thank you. I do have a procedural question because there are no conditional use permits right now. There's 0. Is that accurate?
Correct. If I approve this, there would be.
Okay. And because there's no conditional use permits, do they have permission to keep hosting events?
I don't believe they do, but I can't
Okay.
rule on that because that's an enforcement issue for the
Okay.
county's code enforcement process.
'Cause
You
thank
can
you.
contact the code enforcement process section, agency, whatever it is at the county, and raise that issue. But I don't have any jurisdiction in this proceeding to address that. As I noted, my decision goes forward from when I approve a conditional use permit, if I approve a conditional use permit.
And the conditional use permits, that includes decibels, because I'm getting readings of 97 as of last week. Does that
Yes,
include decibels?
I can't consider your testimony regarding the decibel readings, but there, the code does limit the maximum noise levels that can be,
And that includes
that are
yelling.
allowed.
Is
And
that yelling?
if those noise levels are exceeded during events occurring after the condition, if I approve the application, if those levels are exceeded after that approval, then that would also be a code enforcement issue. And the county can and does uh, uh, respond to complaints and through its enforcement process. They can fine the applicant. If they find violations, they can request revocation of the conditional use permit. So
Thank
there
you.
are procedures to make sure compliance with all the conditions of approval, which also include compliance with the applicable criteria in the code, which is the decibel level.
I appreciate that knowledge. Like I said, I just got this last night, so
Yeah.
I appreciate that. Thank you.
Thank
I'm
you,
done.
ma'am.
I'm done.
Mr. Hall, just in case you want to add anything. If not, I'll close the record. Hearing.
Nothing to add. I agree with your
Okay.
framing of the issues.
Okay. So with that, I'm going to hold the record open, as I noted in my procedural order, until August 21st at 4 p.m. Is that right? Ms. Lord or Ms. Renner?
Yes.
Okay. I'll hold it open until 4 p.m. August 21st for anybody to submit additional written testimony and evidence. Anything you want to submit should be submitted to Ms. Lord at the county. It has to be physically received by the county by 4 o'clock p.m. on the 21st. I'll hold it open for a second week until August 28th at 4 p.m. to anybody to respond to anything submitted during the first week. That second week is limited to responses to issues raised during the first week. No new issues may be raised during the second week. And then for a third week until September 4th for the applicant alone to submit a final written argument. I will be on vacation until September 11th, so I won't get the decision out within exactly 2 weeks. Let me grab my calendar real quick. I'll give you a more specific date. I will do my best to get it out by September 25th. My final decision on this case. I will send my decision to the county. The county will send it to parties of record. So anybody who has testified orally or in writing, or who does so during the open record period will be sure and receive a copy of my decision. If you just want to get a copy but don't need to testify, you can just contact Ms. Lord and ask to be put on the mailing list. But that's what I'm going to do, and that concludes our hearing. Thank you all. Have a good afternoon.
Thank you. Take care, everybody.